This is an appeal from a decision of the Court of Appeal in Northern Ireland in a case called the Queen against Bernadette Hilton. Ms. Hilton was convicted of 3 offences contrary to Section 105A of the Social Security Administration Northern Ireland 1972. Those convictions took place in September 2015. After her convictions, Ms. Hilton was committed to the Crown Court, and that court was asked to make a confiscation order under Section 156 of the Proceeds of Crime Act of 2002. The application was heard by His Honour Judge Miller, QC, on the 20th of October 2016, and he made a confiscation order in the sum of £10,263.50. That was the equivalent of Ms. Hilton's half share in a matrimonial home. She appealed to the Court of Appeal against Judge Miller's order. The Court of Appeal decided that Section 160A, subsection 2 of the Proceeds of Crime Act 2002 required that at the time of making the confiscation order, the Crown Court was obliged to give to anyone who was thought to hold an interest in the property an opportunity to make representations on whether the confiscation order should be made. And of course, in this case, Ms. Hilton's estranged partner, neither the estranged partner nor the building society, which was the mortgagee of the property, had been given the chance to make representations. The Court of Appeal decided that that was fatal to the decision of the judge, and that the confiscation order was therefore invalid. The Director of Public Prosecutions appealed to this court. The Supreme Court unanimously allows the appeal, and it holds that the questions which the Court of Appeal had certified do not arise on the present appeal, because a determination under Section 160A of the Proceeds of Crime Act was not in fact made by Judge Miller. Very briefly stated, because this is an extremely technical case, but very briefly stated, the reasons for the judgment are these. The Proceeds of Crime Act 2002 provides for 2 stages to confiscation proceedings. The first is the making of a confiscation order, and the second, an order securing its enforcement. The first stage is dealt with in sections 150 and 160B. Under 163B, that envisages the making of a confiscation order, and it is clear that those provisions envisage that this should be reasonably straightforward, indeed quasi-automatic. Section 160A of the Act provides that where it appears to a court making a confiscation order that there is property held by the defendant that is likely to be realized, and B, that a person other than the defendant holds or may hold an interest in the property, the court may, if it thinks it appropriate to do so, determine the extent at the time that the confiscation order is made of the defendant's interest in the property. Subsection 2 is an important provision. It provides that the court must not exercise the power conferred by subsection 1 unless it gives to anyone who the court thinks it is or may be a person holding an interest in the property a reasonable opportunity to make representations on it. What we have decided is that the critical question is whether at the stage of making the order, the Crown Court judge made a determination of the extent of Ms. Hilton's interest in the jointly owned property under Section 160A. If made on foot of such a determination, the confiscation order becomes immutable unless there is an appeal. Therefore, a determination under Section 160A effectively extinguishes the opportunity for third parties to make later representations. On the other hand, the judge can, at the stage of making the confiscation order, merely form a view of the extent of the interest of the person in question, in this case, Ms. Hilton, without making a determination under Section 160A. In our view, Parliament intended that this should be the case, as is evidenced from the provisions relating to the second stage, namely the enforcement of the confiscation order, and we refer to Section 199, subsection 8, and in subsection B of Section 199 in support of that conclusion. Essentially, therefore, where the court makes a Section 160A determination, third parties must be afforded the chance to make representation at the stage of making the confiscation order as provided for in that subsection. But where the court does not make a determination and rather simply forms a view at this first stage of the process of the extent of the interest of the person in question, it will have to give third parties the chance to make representations at the enforcement stage. Having carefully examined the transcript of the hearing before the learned county court judge, or rather the learned Crown Court judge, we are satisfied that he did not make a determination under Section 160A, and that therefore the opportunity for third parties to make representations at the enforcement stage continued to exist. For this reason, the answer to the question certified in the certificate given by the Court of Appeal simply do not arise on the present appeal, and the appeal is therefore allowed.